5137, 255341, and 2544. For record should reflect Mr. Lovely is present here in the courtroom today. If I could have counsel for your appearances.
Jericho on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Lovely for all three files.
And Mr. Trush, how did we want to proceed with these cases today?
Your Honor, I'm going to ask for an adjournment of 1 month. I spoke to Mr. Lovely about this. I talked to the prosecutor and the probation department as well. This is a case that was originally signed to Mr. Vernon. I was substituted in on the files probably about 10 days ago. I'm just not up to speed enough for us to be able to resolve it. But I think with a month, we'll be in a position to do that.
Okay, Ms. Coe.
I do not object.
I'm sorry.
I do not object.
Okay. Mr. Lovely, have you had a chance to talk to Mr. Trush about this?
Yep.
Do you have any objection to that?
No.
Okay. All right, so we'll reset this for a plea hearing status conference. As requested by Mr. Trush. Mr. Trush, are there any matters we need other than that to address today?
I don't believe so, Your Honor.
So,
Nothing further.
Mr. Lovely, do you have any questions?
No.
Like Mr. Brooks is present here in the courtroom today. If I could have counsel put your appearances on.
Jericho on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of Defendant George Mertz. Your Honor, we're here on a probation violation. Mr. Brooks is contesting those underlying charges in Osceola County. I understand his attorney is going to be doing something about the search as well as possibly going to trial. So at this point, we're asking for an adjournment to allow that case to play out, maybe calendar 60 days out. I don't believe we have a trial date yet, so I don't believe it is. Do you have a trial date?
Yeah.
What's your trial date?
10, 29, 25.
All right, Mr. Brooks advised me it's 10, 29, 25, so maybe early November.
Okay. It looks like Mr. Brooks has already been arraigned on this. Is that right?
That is correct.
I believe that's correct.
Okay. Mr. Brooks, have you had a chance to talk to Mr. Thompson about this delay in this part of your case?
Yes, Your Honor.
Do you have any objection to that?
Oh, Your Honor.
Okay. Mr. Caven, do you have any objection?
No objection, Your Honor.
Okay. And I was looking at something, Mr. Thompson, can you tell me the time frame?
Yeah, October 29th. It sounds like we have a trial date for that underlying case out of Osceola County.
Okay, so we'll set this for a hearing on the court's November motion day. We'll set it for the mid-month November motion day. So give everybody enough time to get through the trial and decide how they want to proceed with this part of that. Anything else we can address, Mr. Thompson?
I don't have anything else for today's record. Thank you.
Mr. Brooks, did you have any questions? No. Okay, thank you. That's all for today. Versus Brinker, case number 255411. Mr. Brinker is present here in the courtroom today. This was originally set as cause to court that found Mr. Brinker has appeared before the court today, so the court is going to dismiss that show cause of forfeiture. In terms of how to proceed, Mr. Brinker, I know you're representing yourself. Is that correct?
Yeah, correct, Your Honor.
Okay. Did you have an arraignment or a hearing before Judge Burmeister?
I don't think so.
No.
No, I just got found over, sir.
Okay. I just want to make sure, did he ever go through with you the risks and
Yes.
all
Yes,
of
sir.
that of
Yes, sir.
representing yourself?
Yes, sir.
Okay. In light of the previous hearing that you had with him where he advised you of those risks of proceeding on your own behalf, did you still wish to proceed?
Yes, sir.
Okay, representing yourself?
Correct.
Okay. You understand that you do have the right to have an attorney?
Yes, sir.
And that Mr. Thompson is here as a standby counsel?
Yes, sir.
if at any point during this or any other hearing in front of me you want to be able to consult with Mr. Thompson, just let me know. I will take a break and allow you to do that, okay?
Appreciate that. Thank you.
So based on that, the court finds that Mr. Brinker's waiver of counsel is knowing, voluntary, non-equivocal. The court will proceed. Ms. Koch, can you tell me what the prosecution position is at this time?
Yes, Your Honor. We made a offer in February on this case. The case was bound over in April. We've had some adjournments at the beginning of the case in terms of getting it charged and stuff due to Mr. Brinker's health issues. It's about a year old. We'd asked the matter to be set for trial. If Mr. Brinker does not want to avail himself of the plea, which is plea to count 1, operating while intoxicated, third offense, dismiss habitual fourth, and dismiss the DWLS.
Mr. Brinker, have you had a chance to consider that plea offer?
Yes, I wasn't really prepared for this. I thought it was just a hearing for a bond. I apologize.
Okay. Ms. Koch, when was that offer communicated to Mr. Brinker?
It was emailed to him in February. I talked to him about it several times. We do have a court date. Let me just check. I think it's on the next. No, this is the only court date we have. So I would ask that we set it for trial and we can do a final plea cutoff in 30 days.
So, Mr. Brinker, what I'm going to do is get your case on the calendar for trial.
Your Honor, I was wondering if I could, I didn't know this was gonna be a pre-trial conference type thing. I was wondering if I could get a adjournment for, I had a motion for adjournment rather than hospitalized for 4 weeks. And I was wondering if I can get like my ducks in a row and have a pre-trial. This is my first hearing in your court. I wonder if I can get a 6-day adjournment and get my everything in order, because I've been completely hospitalized for the last, and I haven't really thought about this, so to speak, in that context. And I was wondering if I could get 60 days to get my doctor records and all that stuff for this particular case, sir.
On May 27th, he tried to file a motion for a continuance. There was no notice of hearing. I told him he needed to call and get a court date. He said he would do that. That did not happen, and then he failed to show up on the 16th. And then
I was hospitalized.
Yeah, so what I'm going to do, Mr. Brinker, is get a trial date set. I will build enough time in between now and then to allow you whatever motion you need to file. And then I'll set this prior to that trial date for a plea cutoff. So
Okay.
you'll have some additional time to consider that plea offer.
I appreciate that, Your Honor. Cause I just got, today I got another micrological report that I have more stuff of wound care. It's positive for more infection in my hand. So I don't know if I'm gonna be back hospitalized here shortly for that. You know, I brought that with me today just to show you. I had 2 surgeries on my hands recently, and now they're saying I have some other bacteria inside of it that will cause it more infection. So I have an appointment to go see a hand specialist and Travis for that. And that's what I'm saying. Like, I don't know exactly what's going to happen with that if I go back to hospital for another, because I had to be an IV antibiotics in order to get the infection out. And that's what I'm kind of, you know, I don't know. It's whatever the specialists tell me. So I apologize about that. And it was something that I had no idea that even happened. And it was all, I don't know how it happened or whatever, but I had a lot of viruses and stuff in my hands that caused it to swell and have surgeries and stuff. So I apologize.
Okay. All right. So I'm gonna set this for trial about 4 months out. Ms. Koch, how many days of trial do you think we need for this?
We can do it in one day.
So I'm gonna set it for a 1-day jury trial at 4 months out. Our next hearing will be in about 60 days for a status conference. Okay.
Thank you.
And if you have any motions to file, Mr. Brinker, they would need to be set for hearing. And Ms. Spendler's right about the process. If you have a motion.
I gave him notice of hearing that somebody wasn't here, and I gave it to the person across the hall to give to the court, because I did submit some motions, and they did notify me that I needed a notice of hearing, and I went and got it and got it signed and submitted it for the day I was supposed to be here, but I was in Traverse City Hospital, so because I had every intention of being here. I was filing motions and everything, so it just, like I said, it wasn't something I had planned.
Yeah, so there's two steps to the process. You have to call my office, talk to Jennifer.
I did, yeah, I did that.
So you need to get a date and time from her, and then once you have that, then you need to file that notice.
Yes, sir.
With the clerk.
Yes, sir.
So, you'll have 60 days to do any of those.
Yes, sir. Got it. Thank you.
And you're will the 60 days, the status conference, that'll be the final plea cutoff and date.
Right, so then, at that time, Mr. Brinker, you also need to have a decision whether you want to enter.
Yes, sir.
Okay.
Thank you, sir.
Your Honor, I think today was set up as a motion to potentially revoke the bond. I assume that's not gonna occur.
Right, yeah, that, since Mr. Brinker submitted himself to the jurisdiction of the court, under the court rule, further against forfeiting the bond, either with regard to Mr. Brinker.
Thank you, sir.
Okay,
Thank you.
that's all for today.
Thank you, sir.
It's here in second 45, so.
All right, let's talk about that. The docket today brought us People v. Michael Lovely, where Judge George Mertz kept things moving in his calm, matter-of-fact way. Lovely's attorney, Richard Trush, had just stepped into the case about 10 days earlier, so he asked for a 1-month adjournment to get up to speed. The prosecutor didn't object, and Lovely himself agreed without hesitation. It was quick, professional, and the kind of procedural step that ensures the defense isn't walking into a hearing half-prepared. Next was Jordan Brooks on a probation violation matter tied to an ongoing case in another county. His attorney, Jason Thompson, explained that Brooks is contesting those charges and still awaiting trial, scheduled for late October next year. Yes, you heard that right, 2025. The judge agreed to set the probation violation hearing for mid-November to give the other case time to play out. Everyone was on the same page, and the exchange had a cooperative tone. Then came what was arguably the most eventful case of the day, People v. Mr. Brinker, representing himself. Brinker confirmed that he understood the risks of going without an attorney, though the court had standby counsel available if needed. The prosecution laid out a plea offer from February, but Brinker seemed caught off guard, saying he thought the hearing was for something else. He asked for more time, explaining that he'd recently been hospitalized for 4 weeks and was still dealing with serious hand infections, requiring multiple surgeries and possible future hospitalization. The judge tried to balance the need to move the case forward with compassion for Brinker's health issues, setting a trial date about 4 months out with a status conference in 60 days. He also explained the process for properly filing motions, procedural point Brinker seemed to have partially missed in earlier attempts. The overall atmosphere was steady and pragmatic, though Brinker's medical situation added a layer of unpredictability. Judge Mertz remained patient, allowing Brinker the time he needed while making sure the trial timeline stayed realistic. The attorneys were accommodating, and even though Brinker is going it alone, the court made sure he understood his rights and responsibilities. This wasn't a day for fireworks, but it showed how much of courtroom work is about making sure everyone's on the same procedural page before the real action begins. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.